This is Michael Popok, Legal AF. Why Donald Trump keeps relying on Alina Habba to make major arguments in appellate courts is frankly beyond me, but he keeps doing it once again. This time in the E Jean Carroll case, this having to do with the trial that's upcoming in January just on damages because Judge Kaplan ruled last week that Donald Trump is not entitled to a second trial about defamation because his 2019 statements while president are basically identical to the 2022 defamatory statements he made against E Jean Carroll that a jury already found was defamatory. Now we have an appeal by Donald Trump because he says, well, but I was president. What about presidential immunity? To which the Second Circuit Court of Appeal just yesterday, in an oral argument with Alina Habba, said, yeah, what about your immunity? You didn't raise it for at least a year or at least 8 months into the case. Why isn't that waiver, Miss Haba? And started to grill Alina Habba during her oral argument presentation to the Second Circuit. How do we even get there? First, it starts with a decision by the federal judge, Lewis Kaplan, that he would not stay his ordering that there be a trial in January on damages. In other words, how big of a check should Donald Trump write to E Jean Carroll for his defamation while president? Whereas Joe Tacopina, before he was Trump's lawyer and loser in the last trial of E Jean Carroll in May, in an interview said when Donald Trump was the defamer in chief of E Jean Carroll, you know, when he was a pundit on television, he was cracking wise on Donald Trump until he got a retainer and started representing him. So defamer in chief Donald Trump tried to argue that he had presidential immunity, except he didn't raise it for about 8 or 9 months into the case. That troubled Judge Kaplan, the trial judge, who found that any attempt to appeal the matter, what would be effectively an interlocutory appeal, meaning an appeal before final judgment, is frivolous. He actually certified Donald Trump's appeal a month ago as frivolous. Okay, that's how the Second Circuit Court of Appeals got it. When it came up from the lower court, it was stamped I don't know if it was literally stamped, but it probably was stamped frivolous. And that's where the starting point is. That leads to an emergency hearing only because Alina Habba decided, hey, I want to tell the entire world and I want to do it early, that I made another boo-boo. I don't know what they call it around the Trump dining room, but Alina Habba made another boo-boo. She forgot to raise presidential immunity as a defense, not that it would likely be a defense. And she said the reason she didn't raise it earlier is because she was really busy and it was very complicated. The case was so complicated, she didn't know when to raise it. I'm going to play for you a couple of clips that shows you that she is on the ropes with the Second Circuit Court of Appeals with 2 different judges with a 3-judge panel. Now, let me set the stage. This is not the panel that's going to hear the ultimate merits of the appeal itself, whether presidential immunity should or shouldn't be applied, whether they were late and it waived. That's called a merits panel. They handle the merits of an appeal. When you come up early on a motion for expedited or a stay, which is what they're seeking, or an injunction, you come up early and you hit a different panel. That panel is called a motions panel. They don't get into the substance of the appeal except as it relates to the motion in front of them. So the hearing you're going to hear, we have the oral argument, is from the motions appellate panel, which is 1 Trumper and 2 Biden judges, that not the actual substantive hearing. And what they ultimately concluded, you'll hear it on the clip I'm going to play next, is why are we here? What's going on down below? You have till January. It's a couple of more weeks for the substantive merits panel to be convened and to review and hear all the briefing. So why are you here? This is what I tell my associates when I train them for court. Judges are impatient and they want to hear in the first minute 2 things. Why are we here and what do you want? And Alina Habba violated both those cardinal rules in her presentation, while in the same breath admitting that she waived the defense for Donald Trump because she raised it so late. Let's play the first clip where she concedes that it's waived as the judge tries to throw her a lifeline like, Well, where is it in any of the papers below in the trial court that indicates that you preserved this issue for the appeal and you raised it timely? Let's play that clip.
And that's something that is incredibly important. So,
you know, one of the things your adversary argues is that if we agreed with that, we'd actually be tying a president's hands who might want to waive the immunity, have his day in court, and presumably vindicate himself. So why shouldn't we be cautious about a decision that would tie a president's hands?
because no single president in this country, be it President Trump or President Biden or President Obama, no president should have the right to change the constitutional separation of powers that are divested of the executive branch, because it is public policy's interest that a president be able to address questions of public concern.
What is the best case for that? I mean, you speak broadly about separation of powers principles, and I appreciate that.
Sure.
What is Nixon.
Nixon v. Fitzgerald is on point, in my opinion. Nixon v. Fitzgerald addresses this exact issue. It states that you absolutely have to, for very many reasons,
and says that the president is without power to waive immunity.
No. What it says is that the president, I can quote it, Your Honor, before exercising jurisdiction, it must balance the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. That's why it's my position that I don't think any president should be able to waive that.
That's different from, I think, the answer you provided to Judge Reggie. So Nixon doesn't say that the president is without power. There's this issue of a presidential decision or executive decision about when to waive and when not to waive, and when to appear in court. And I didn't hear anything in the language that you provided in Nixon that addresses that.
Well, I don't think I'm understanding your question, Your Honor. I apologize, but my position is still that it's not
maybe because
waivable.
I'm not sure that I understand the answer
Okay.
you've given resting on Nixon.
Okay.
Which doesn't seem to answer the question of whether the executive can waive immunity.
He cannot.
Okay, what you just heard was a struggling attorney trying to answer a very simple question, because the answer to that simple question is she waived. She raised it 8 months into a case. You don't raise something like presidential immunity early, then you waive it. Okay, you can't continue to litigate the case and find out what the result's going to be. And oh shit, I lost. Okay, presidential immunity. That's not how it works, Alina. But then it got worse, because then she decided to mislead the rest of the panel about the law. So first she lied on the facts. You heard that clip. And the next clip, you're going to hear her lie on the law. Let's play that clip.
Which I believe gives us good grounds, even if we use the traditional factors, even if we said that there wasn't divestiture of jurisdiction, which I argue that there is. I believe that under the state factors, that also grants relief to President Trump here. The likelihood of success on presidential immunity is not waivable. And for the first prong, our argument is that in the Supreme Court, President Nixon v. Fitzgerald.
I'm sorry, you're saying it's not waivable, and you've also asserted that you had asserted the presidential immunity, absolute immunity defense at different points over the past 3.5 years of the litigation, but I was not seeing that in the record. Could you point to the earliest time at which you made the absolute immunity argument and briefed that?
Sure, Your Honor. First, yes, our position is that it's not waivable. And if we were to go by Judge Kaplan's position that we needed to assert it, we did assert it in 2 different instances, well, 3 instances, 2 motions. The first, I can give you the exact date if Your Honor would like, but we asserted it in a motion for summary judgment.
I just didn't see it in the papers.
Sure, no problem, Your Honor. I can give you the exact date. It was noted that we did it on the motion for summary judgment, which was December 20.
I have the brief. Is there a place that so there's a discussion of presidential immunity generally.
Are you asking me where?
The evolution of the absolute immunity. So that would have been in December
2022. In our motion for summary
so 8
judgment.
months ago.
in our
basically. So already the litigation had been going on for several years, is that right?
The litigation had been going on, but I think that's a good point, Your Honor, that I'd like to address. Our litigation was very complicated. We had the Department of Justice step in, and the Westfall Act, as this court remembers, which is, by the way, more is a subjective test, not an objective test like this case, took years in 3 different courts for us to address whether that was an issue here. And unfortunately, we never got to a definitive answer on that. But that's a perfect example, Your Honor, of why this case was so complicated. Obviously, in hindsight, if you look at it, and I understand what my opposing counsel is going to argue, this case was not plain and simple. We had 2 matters.
You're asserting,
you-
please go ahead, Judge Radji.
Was there anything precluding you from also asserting presidential immunity at the same time that you argued Westfall immunity? I mean, parties argue in the alternative all the time.
There's nothing precluding it, but I think I don't think it's relevant because I truly believe that, and the case law states that you cannot waive presidential immunity based on separation of powers.
All right, so what's going on there? Alina Habba, to try to bail herself out, tries to rely on this U.S. versus Nixon case and for the proposition that a presidential immunity can never be waived by any president. It's unwaivable, which is, I've never heard of this doctrine in my life. And neither did the judges on the Second Circuit Court of Appeals, who said very, very politely, where in Nixon does that proposition reside? I don't see that. And he didn't see it, that judge, because it doesn't exist in that case. So she's misleading the panel about her case. She's holding on as a life preserver to a case that's really an anchor that sinks her entire argument. And so the panel did exactly what the panel should do. The panel, having questioned Alina Habba, like, why are we here? You have a full-blown appeal on the issue of presidential immunity and waiver and all of that before another panel, the merits panel, in a couple of weeks. What's really going on in September with Judge Kaplan, the trial judge? You need immediate relief right now because you have to show, things like irreparable harm, prejudice, no prejudice to the other side, things like that she could never meet. And they said, why wouldn't it just be better to expedite the briefing schedule for the real appeal and have you be heard then? Why are you wasting our time now? To which Alina Habba said, I'm just very busy. I'm really busy. I've got a lot on my plate. I'm not making this up. I got a lot on my plate. And I don't know if you've heard, Donald Trump has a lot on his plate too. To which the lawyer for E Jean Carroll, because he argued too, Joshua Matz, said that can't be prejudice, that she's busy. We've got a trial date in January, Judge. If we don't hold fast to that trial date in January, my client is not going to get justice. Justice delayed is justice denied. And the way the criminal cases are piling up on Donald Trump, we're not going to be if we miss January's window, it's going to be 2025 before my 75-year-old client gets her day in court. That's unfair. Including they're trying to get an injunction against Donald Trump to stop defaming her along the way. So today we finally got the ruling from the appeals panel, the motion appeal panel. They said denied on the stay, but we'll expedite the briefing on the rest. You can go argue, Ms. Haba, in a few weeks, rearrange your schedule, try to make it work for yourself in your full briefing as to presidential immunity and why you haven't waived it and why it's still applicable and why it denies Ms. Carroll the right to a trial on damages because the court's already found that she was defamed. And that's the ruling from today. That's the full squaring of the circle related to E Jean Carroll and Alina Habba. But I just think it's fascinating. And the reason I was so hot to do this hot take is to demonstrate once again, this is now, I can count at least on 3 fingers the times that Alina Habba herself has screwed up a case and left her client worse off as a result. And 2 of them are in E Jean Carroll. In E Jean Carroll, the judge chastised her early on for screwing up the DNA evidence issue related to the black dress that E Jean Carroll had held, and he chastised her for doing it. And then in this case, we have the waiver of the presidential immunity because it was raised for the first time 8 months into the case. That's a no-no. And then even in the New York Attorney General case, which is going to trial on October the 2nd, that apparently she's still litigating, which came as a shock to me, she screwed up Donald Trump's ability to get a jury trial instead of a judge bench trial. And he hates this judge, Judge Engoron, only because he's ruling against him every time, installing a financial monitor on top of the Trump Organization business to watch every piece of paper related to money go by, ruling and finding Trump in contempt and fining him $10,000, finding his motions to dismiss frivolous. He wants to get about as far away from this judge as possible. But within 15 days of the New York Attorney General saying ready for trial with a note of issue under New York procedural law, she had to file a jury demand and she didn't. So she waived it again. This is what happens when you hire this kind of lawyer to represent you, Donald Trump. I'll continue to follow this kind of matter, both on E Jean Carroll, everything else that sits at the intersection of law and politics. One place, the MeidasTouch Network on this YouTube channel. That's where I do everything. And we have all the hot takes for me. I got about 400 of them, just like this, sitting over in playlists on YouTube. Free subscribe to MeidasTouch. Help them get to 2 million free subscribers. It's a way to help. We don't have outside investors. And then every Wednesday and Saturday, I do a show called Legal AF, just like this one, except I got a co-anchor on Wednesdays, Karen Friedman Agnifilo, a co-anchor on Saturdays, Ben Meiselas, and we break it all down, you know, top 5 stories at that midweek or at the end of the week on Legal AF. If you like what I'm doing, give me a thumbs up and a comment here. Helps with the ratings. And then until my next hot take, this is Michael Popok, Legal AF.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.